As 2022 draws to a close, it's worth reflecting on some of the major headlines out of the Supreme Court this past term and looking forward at what some of the big decisions will be coming down. The Supreme Court has made major headlines this year, and the biggest story of all was the court's decision to overrule the landmark decision in Roe v. Wade. Roe v. Wade was a 1973 landmark decision that allowed a constitutional protection for abortion rights up to the point of fetal viability, which is around 23 weeks. And the conservative legal movement for decades has been trying to get that case overturned. And now that there is a 6-3 conservative supermajority on the court, they succeeded in June when the court, on a 6-3 basis, overruled that landmark decision.
Like the court and the country, Washington is split over the U.S. Supreme Court's decision Friday to overturn its decades-old Roe v. Wade abortion case.
The health and life of women in this nation are now at risk.
It will save the lives of millions of children.
President Joe Biden called the 6-3 ruling that revokes women's constitutional right to abortion a tragic error.
The court's decision to do so will have real and immediate consequences.
About a dozen states have already passed so-called trigger laws that now outlaw most abortions.
It's a slap in the face to women.
House Speaker Nancy Pelosi said it hits especially at the poor and people of color. She and other Democrats in Congress, like Nevada Senator Catherine Cortez Masto, said they will continue to push to pass federal laws to restore abortion rights.
It matters who we elect in this country, who are going to stand up for our rights or take them away.
Many Republicans, though, including Louisiana Congressman Mike Johnson, cheered the ruling and have staunchly opposed abortion rights legislation.
Abortion violence is the #1 killer of children in America until today.
Johnson and others, like Missouri Congresswoman Ann Wagner, called on more states to take advantage of the ruling.
And swiftly pass protections for our vulnerable babies.
And in effect, what that did was it kicked the issue to the states and said, conservative states, if you want to cut back access to abortion, you are now free to do so with some limited exceptions. Blue states, if you want to continue providing expansive protections within certain limits, then you are free to do that. And so we've seen really a scrambling of abortion access across the country, where red states have taken steps to seriously curtail or even ban, with only limited exceptions, access to abortion.
Offshore, about a 40-minute boat ride, depending on weather, is where hundreds of Texas women have already gone to seek an abortion.
I couldn't travel out of state, and I couldn't, afford that, really. So I was just searching for another option, and that's how I came across Abort Offshore.
This 24-year-old Texas woman who wants her identity protected says she went there because she's got a rocky relationship with her boyfriend, among other reasons.
I cannot have a baby right now.
Abort Offshore was launched in mid-July by a man named Michael Kimbrough, who goes back and forth from New York and Texas.
No, I should not be running any sort of medical facility.
He decided to create the business after the leak of the Supreme Court opinion that overturned the Roe v. Wade precedent.
Why should women trust you and go through with things?
They shouldn't, and they shouldn't have to.
Kimbrough says the process to get an abortion through Offshore starts with a physician referral.
There's a number of physicians that are working with us. They then give a code to the sonogram. The sonogram company then says, okay, this person is real. So it starts with, say, a 4-letter digit code. They then give them another unique identifier, and they then text our number. And then that's when we schedule them on the boat.
Kimbrough tells me so far, more than 200 Texas women have used his service.
It sounds really covert and crazy, but unfortunately these laws require it.
Once a patient is verified, Offshore arranges a pre-boarding meeting at a hotel with what's called a patient advocate in the Galveston area. The patient then leaves their phone behind. A car takes them to an Airbnb home near the water. They then go to a private dock and out on the water.
I spoke to somebody yesterday that asked me, why would you even advertise this? And I was like, well, I wanted to see how much trouble I'd get in before really we scaled, and I put a lot of money in this.
Now, Kimbrough has been accused of fraud multiple times, but never convicted.
Is this something that you're doing as just another fraudulent type deal to make money, or is this something that you're truly doing to help women?
Neither at this point. There's a lot of other people that are going to exploit this situation.
Are you not
That's what I was
exploiting the
hoping.
situation, though?
Of course I am. That's what I'm saying.
He tells me he wants what he's doing to draw attention to the lengths women will go when there's a ban on abortions.
It was either this or having a kid.
What's significant about this case is it signals that the 6-3 conservative majority court is willing to move the court very quickly and very far to the right. One of the biggest questions headed into last term was just how quickly and how far in a conservative direction this new court would move. And the overruling of Roe v. Wade definitively answered that question. This court is willing to move very sharply and very quickly to the right. The overruling of Roe v. Wade was handed down in a majority opinion by Justice Samuel Alito, but there was a separate concurring opinion written by Justice Clarence Thomas, who is one of the most conservative justices on the bench. And Thomas signaled that he would have gone even further. He would have looked at the provision of the Constitution, the Equal Protection Clause of the 14th Amendment, and specifically a long-standing legal theory called substantive due process, which is where the Roe decision was rooted. And Thomas said that the court should not only be skeptical of Roe's underpinnings, but also other decisions like Obergefell, the decision that legalized gay marriage, and others that are also rooted in the substantive due process. It's unclear whether there are 5 or more conservative justices who will go along with Thomas. But the mere fact that Thomas would write a concurrence expressing such a, what some see as an extreme view of the law, really raised concerns among those in the LGBT community and those who advocate on behalf of women's rights. Another important aspect of this case was the leak in May, more than a month before the actual decision was handed down.
In this extraordinary statement, Chief Justice John Roberts confirmed the authenticity of the leaked draft opinion proposing to overturn Roe v. Wade, but he says it's not final. Roberts calls the leak an egregious breach of trust, and he announced he's opening an investigation. The Supreme Court draft opinion obtained by Politico would strike down Roe v. Wade, the 1973 decision guaranteeing abortion rights, and the subsequent 1992 ruling that largely maintained those rights. President Biden discussed the stakes.
If this decision holds, it's really quite a radical decision.
Congressional Republicans were not focused on the content of the draft opinion. Senate Minority Leader Mitch McConnell condemned the breach as an attack on the independence of the Supreme Court. Several U.S. states have passed trigger laws that would outlaw abortion if the High Court strikes down Roe. In Illinois, abortion would remain legal.
The implications of reversing Roe are terrifying. It goes far beyond ending the right to an abortion. It means an end to the constitutional right to privacy.
We are not going to turn back the clock, no matter what the Supreme Court says, no matter what other states do.
Planned Parenthood Illinois is preparing to take on women who travel from states with abortion restrictions.
Illinois could expect to see between 20 and 30,000 additional abortion patients.
For many women lawmakers and activists, abortion is personal.
We want to make sure that everybody has the care that they need, because abortion is medical care and it's life-saving medical care.
Anti-abortion rights groups like Pro-Life Action League applauded the draft opinion.
A victory for the pro-life movement, but I think more importantly, a real victory for the United States. I think that having abortion play such a central role in our federal politics over the past 50 years, it has just really been incredibly toxic.
This marked one of the most stunning and egregious breaches of Supreme Court secrecy and security protocols. Chief Justice John Roberts launched an investigation. The public has not been provided many details into where things stand with that investigation. There's all sorts of speculation about who may or may not have been motivated to leak this. Some theorize that perhaps it was somebody on the political right who wanted to leak it so that the public could see that justices like Brett Kavanaugh, who is the median justice, that he had signed on to this draft opinion overruling Roe v. Wade in hopes of locking in his vote. Others say that maybe somebody on the political left was motivated to leak this in hopes that the public backlash would cause some of the more moderate conservative justices to rethink their plan to vote in favor of overruling Roe v. Wade. What we know is that The leak of the draft opinion ended up looking virtually identical to the opinion that was ultimately handed down, which overturned Roe v. Wade and eliminated what had been a constitutional right to abortion access for almost a half a century. Another major case that was decided last term by the Supreme Court involved the expansion of the Second Amendment. It was a case that looked at whether New York had set up a rule that was too stringent in how the state gave permits for the concealed carry of guns. And what the Supreme Court decided was that the Second Amendment broadly protects the right to carry a gun outside the home by law-abiding citizens for self-defense.
Where are we safe now?
Tonight, shockwaves after a Supreme Court ruling. The High Court just blocked the century-old New York law that limits guns in public. Reaction to the court's ruling was swift. In Washington,
limiting concealed carry permitting laws is a recipe for disaster.
And right here in New York City.
This decision has made every single one of us less safe from gun violence.
The case was brought by a group of New York gun owners. They wanted to carry their weapons outside of the home, but state law required them to prove why they needed to carry a concealed weapon for self-defense. Today's Supreme Court ruling found Americans do have a right to carry firearms in public for self-defense under the Second Amendment.
We do not need people entering our subways, our restaurants, our movie theaters with concealed weapons. We don't need more guns on our streets. We're already dealing with a major gun violence crisis.
The court ruled 6-3 along ideological lines. This decision is expected to make it tougher for all states to restrict guns. Here in New York, lawmakers spent the day poring over the court's ruling, preparing to respond.
This is New York. We don't back down. We fight back.
Erica Ford says her work will be deeply impacted by the court's decision. Ford is the founder of Life Camp Inc. For 20 years, they've worked to prevent gun violence in Southeast Queens.
We have to be cautious of showing up in spaces for the future. We're at basketball games or concerts, and now there's a question of who has a legal gun and what are they going to use it for.
The New York State Republican Party welcomed the Supreme Court's decision, saying in a statement, "Bravo. Today's Supreme Court ruling is exactly as it should be, a final authority that protects the constitutional rights of citizens against a dictatorial government."
What this has done is created some confusion in the lower courts about what the Second Amendment protects or doesn't protect. The Supreme Court said that what judges should do going forward is look to the history and traditions of gun regulations in America. But this has led to a situation where some judges scanning the historical record find support for certain gun control measures and other judges find that support lacking. It seems like the situation now is inevitably going to create kind of a patchwork of gun control measures across the country. And most experts in Second Amendment and court watchers think that it's really only a matter of time before the Supreme Court is asked to wade into this issue again. Another major case that was decided by the Supreme Court involved how much power the federal government has to regulate climate change. This was a challenge that was brought by the state of West Virginia and a number of other states challenging the regulatory authority of the Environmental Protection Agency. And the argument that the conservative states put forward was basically that, look, the Environmental Protection Agency, yes, it has power to regulate environment, but it doesn't have power to the extent that it is now exercising it. And the reason why it doesn't is because Congress did not explicitly say that the EPA could regulate pollutants that contribute to climate change. So the big picture here is, while this decision resolved the dispute between the red states and the EPA for now, there's big questions about just how broadly this case is going to be applied going forward. Many experts in administrative law say that the test that the Supreme Court announced in this case, the so-called major questions doctrine, could be used to curtail government power in a number of ways going forward. What the major questions doctrine says is that if an agency tries to take on an action that would have major political or social or economic consequences, then there needs to be an explicit, express authorization of that power by Congress to the agency. Otherwise, the action is presumably unlawful. So there's a number of different ways that this case may be applied going forward. In addition to deciding some major cases last term, the Supreme Court this very term is also hearing some major disputes that could fundamentally reshape major aspects of American society. And one of the biggest cases involves the use of affirmative action in college admissions decisions. The issue before the court is whether race-conscious admissions policies at Harvard and the University of North Carolina violate equal protection. And the challengers here say that if you allow race to be a factor in an admissions decision, that opens the door to admissions officers engaging in the kind of crude stereotyping that the law really frowns upon.
Supporters of affirmative action rallied outside the Supreme Court Monday, while inside the justices heard two cases that could upend the decades-old practice, allowing universities to consider race when admitting students.
I believe that affirmative action is one way for all of us to be able to tell our stories and our truth.
In separate arguments before the court, the University of North Carolina and Harvard both argued the practice is necessary to promote diversity on campus.
We know that every student at Carolina has earned their place.
Justice Ketanji Brown Jackson and Justice Sonia Sotomayor underscored race is just one of several factors considered by schools.
When you give your race, you're not getting any special points. It's being treated just on par with other factors in the system. No one's automatically getting in because race is being used.
But the court's 6 conservative justices expressed skepticism. Justice Samuel Alito suggested the inclusion of race is innately unfair.
If you give a plus to a person who falls within the category of underrepresented minority, but not to somebody else, you are disadvantaging the latter student.
And Justice Clarence Thomas poked holes in the university's goals.
I've heard the word diversity quite a few times, and I don't have a clue what it means. It seems to mean everything for everyone.
Supporters of affirmative action say that if the court takes the dramatic step of saying that race can no longer be used in admissions decisions, that what you would have is, in effect, a massive setback for historically underrepresented minorities who want to attend the most competitive schools and universities and schools that traditionally have been a pipeline to some of the biggest corporate jobs in America. So critics say that the stakes here are just enormous, and there's going to be a lot of attention to see how the court ultimately decides this issue. One big case before the Supreme Court this term is a case called Moore v. Harper. It's a dispute that came out of North Carolina. It involves partisan gerrymandering. And here, Republican lawmakers in North Carolina are asking the court to do something that's quite dramatic. They're asking the court to embrace a view of the Constitution, particularly a provision of the Constitution called the Elections Clause. And what they're arguing is that the Supreme Court should rule that the only body of government at the state level that has any say over how federal elections are carried out at the state level is the state legislature. They want state courts to have no authority over the matter. They don't want governors to be able to weigh in on these matters. What a lot of experts say is that this raises major concerns for democracy in America.
From the state capital of Raleigh to the nation's capital, a group of advocates boarded a bus Tuesday to witness arguments in a historic case before the U.S. Supreme Court. It's called Moore v. Harper and gets its name from Republican State House Speaker Tim Moore and this woman, Becky Harper.
I'm not an attorney. I'm just a voter who's very concerned.
Harper works in real estate and is on the board of Common Cause North Carolina. The group sued Republicans in the legislature over how they drew the state's legislative districts.
This case is so important because I care about fair elections. And really, I'm fundamentally concerned about polarization and extremism.
Democrats on the state Supreme Court found the Republicans illegally drew North Carolina's 14 congressional districts to try to make it easier for Republicans to win seats. The court ultimately adopted its own map of those districts. There ended up being a 7-7 split between the two parties in the election. Republicans say the court went too far and took the case to the U.S. Supreme Court. They're arguing what's known as the independent state legislature theory, saying state legislatures have the sole authority to regulate federal elections in their states. Jeanette Doran is with the North Carolina Institute for Constitutional Law.
Everyone needs to know their limits, including Supreme Court justices.
Critics of the theory say the case could have implications for voting rights and legislatures accepting election results.
It's not going to become a free-for-all and legislators will get to do whatever they want. We'll still have U.S. and state constitutional restrictions.
Up to this point, state courts have been able to weigh in and say that maps are too skewed and too distorted and that they need to be redrawn to make things fairer. If the Supreme Court adopts this really muscular view that's often referred to as the independent state legislature theory, then what we could have is a situation where gerrymandered maps that give a huge advantage to one party and a major disadvantage to the opposing party would not be reviewable by any court. The concern that many experts express is that what this could do is really deeply entrench minority rule in states that already are quite heavily gerrymandered. The Supreme Court recently announced that it would hear arguments in a dispute over President Biden's student debt relief program. Arguments are scheduled to begin as early as February, and what's at issue here is the Biden administration's effort to reinstate a program that would offer up to $10,000 in relief from student debt to those making under $125,000 a year.
It's easy, it's fast. The application for federal student loan relief is now available. President Biden calls the application process short and simple. Borrowers who make less than $125,000 need to apply to get the offered $10,000 in loan forgiveness. And for Pell Grant recipients, that number could be as high as $20,000. This is a game changer for millions of Americans. We get moving. Over the weekend, a test site went live, and the White House says 8 million people already applied. The White House estimates about 95% of Americans with student loans are expected to qualify for the relief. 40 million Americans can stand to benefit from this relief, and about 90% of that relief is going to go to people making less than $75,000 a year. The news comes as a federal judge prepares to hear a lawsuit from 6 Republican states designed to stop the president's plan. Republican members of Congress and Republican governors are trying to do everything they can to deny this relief, even to their own constituents. The Department of Education says their goal is to forgive the debt before student loan repayments resume in January.
Currently, that program has been put on hold by 2 separate courts. One court, the 8th Circuit, blocked the debt program, which prompted the administration to file an appeal to the Supreme Court. There's a separate case that arose from Texas, which is currently pending in the 5th Circuit, and the Biden administration may decide to appeal that to the Supreme Court too. There's been a number of challenges to this program that have not had the effect of blocking it, including 2 cases that went up to the Supreme Court on an emergency basis, but which were turned away unilaterally by Justice Amy Coney Barrett. But what we see here is now that the Department of Justice, now that the Biden administration is involved, the court has said, we don't want to issue a ruling on an emergency basis. We think that this issue is important enough for us to put it on our merits docket, for us to hear arguments in the case, and to get full briefing in the matter and to hear from all stakeholders involved, because it is an issue with such enormous stakes. In addition to taking on some major cases this term, the Supreme Court also made news because of its changing composition. We saw the departure of Justice Stephen Breyer, who was kind of a moderate liberal justice, who was replaced with the nation's first female African-American Justice Ketanji Brown Jackson, who is a former clerk of Justice Stephen Breyer.
It has taken 232 years and 115 prior appointments for a Black woman to be selected to serve on the Supreme Court of the United States. But we've made it.
A celebration at the White House for Judge Ketanji Brown Jackson, becoming the first Black woman ever to reach the nation's highest court.
The road toward our more perfect union is not always straight, and it is not always smooth, but sometimes it leads to a day like today.
The event happening as a COVID-19 outbreak has sidelined several lawmakers. 3 Republican senators joined Democrats yesterday voting to confirm Jackson, following contentious hearings with accusations President Biden called vile and baseless.
In the face of it all, Judge Jackson showed the incredible character and integrity she possesses. poised.
She'll replace the retiring Justice Stephen Breyer, and the current 6-3 conservative balance on the court will remain the same. The Harvard-educated Jackson is a former federal public defender currently serving on the U.S. Court of Appeals for the D.C. Circuit.
No one does this on their own. The path was cleared for me so that I might rise to this occasion.
Illinois Attorney General Kwame Raoul attended the celebration.
She talked about being one generation removed from segregation. That journey, and it really is not the journey that you need to trace back to slavery or trace back to segregation. You just trace it back to the hearings and how she was treated during the hearings, as well as how she was treated by those who did not have the dignity to be on the floor when she was affirmed. But the way she has handled it all is tremendous, and I think she's going to be a tremendous addition to the court.
She's expected to do things a little bit differently than Breyer. Justice Ketanji Brown Jackson is the only justice on the bench who has experience as a public defender. She's expected to perhaps show a little bit more sympathy for criminal defendants compared to her predecessor, Justice Stephen Breyer. It's still a little bit too early to tell exactly how she's going to come out on key issues, but what we have seen so far is that she's a very active questioner. This is something that we saw when Ketanji Brown Jackson was a circuit court judge on the DC circuit, somebody who really liked to engage with the advocates before the court and ask probing questions, and particularly to bring the legal issues that can sometimes be a little bit abstract, to bring them back down to the practical reality of what the stakes are of the decision at hand. So her nomination and seating on the bench already is historic, and we can expect her to round out the 3-member liberal wing of the Supreme Court going forward. When the Supreme Court overruled Roe v. Wade, in its majority opinion, Justice Samuel Alito wrote that their decision would hand the issue over to the democratic process, meaning it would give a chance for Americans in states across the country to weigh in on these decisions and allow their state legislatures to pass measures that either bolstered protections for abortion access or curtailed them, depending on what the will of voters was. What we've already seen in Kansas and in a couple of other states that put abortion access on the ballot is that in a number of states, this decision by the Supreme Court to overrule Roe v. Wade was quite unpopular. Many political analysts who looked at the results of the midterm elections say that what that election stands for, in large part, was a repudiation by the American public of the Supreme Court's decision.
A political earthquake in Kansas that is sending aftershocks across the nation.
Knowing that Kansans still have a constitutional right to make their own private medical decisions and to get abortion access, it is so important.
A constitutional amendment that could have reshaped women's rights from western Kansas to the Missouri border fell short by nearly 20 points. A victory for Rachel Sweet, the campaign manager for one of the organizations that led this movement. She says it was bigger than what political party you were a part of.
It is clear that Democrats, Republicans, Libertarians, unaffiliated voters across the state were voting no in record numbers.
Turnout in the state of Kansas surpassing any previous primary, with over 50% of voters making their feelings felt.
Grassroots support and campaigns really can work, and that's what we saw play out in Kansas.
The grassroots organizing reaching nearly 1 million Kansans, and the results of this race drawing the eye of President Biden, who says in part, this vote makes clear what we know. The majority of Americans agree that women should have access to abortion and the right to make their own healthcare decisions.
I think Kansas is sending the message that we definitely do not want politicians being the ones to make our reproductive healthcare decisions.
In the end, the no side understands how much the stakes rose when Roe v. Wade was gone.
You might have agreed, but maybe you wouldn't have taken time off work or figured out childcare to get to the polls before. But when Roe fell, people saw the backstop is the state protection, and we have to keep it.
There are many who see the fact that Democrats were able to hold on to the Senate and mitigate their losses in the House as a strong signal that the Supreme Court, as it's currently constituted with a 6-3 conservative majority, is issuing decisions that tend to be more conservative than the average American voter.